Hearing to Anthony Henry and another against Attorney General of St. Lucia.
Mr. Remlogan.
My Lord, should it please you in this matter, I appear for the appellant. Mr. Robert Strang and Catherine Bailey of the UK Bar are with me, and Ms. Lydia Faisal of the St. Lucian Bar, who did the case in the courts below, appears with us as well. We're instructed member Mr. Jared Jagru from Freedom Law Chambers. My learned friend Ms. Catherine Deal, King's Counsel, instructed by Charles Russell Speech, she appears for the respondent. My Lords, I don't propose to spend too much time on the facts of the matter. There's a pretty lengthy and detailed statement of agreed facts and issues, which you'll find at page 542. Perhaps I can pick it up by taking you to the High Court judgment, where in one or two paragraphs we can see what the relevant introduction would be. If I take you to page 313, you will see this is the High Court judgment at page 313, and you will see in respect of Mr. Francis Noel, the judge records that he was arrested on the 13th of December 1987 at the age of 36. He was charged with grievous harm and held on remand until his arraignment on the 20th of July 1992, when he was found unfit to plead and ordered by the judge to be detained at the Royal Jail until the Governor General's pleasure shall be known. He remains up to this day at that facility, and in total he spent 32 years for an offence that carries a maximum term of 10 years. Now, my Lords, one feature of the case that troubled me when I read these opening introductory paragraphs is the fact that both appellants, as you'd see in due course, spent almost 4.5 years on remand prior to being called upon to enter their plea. And that's a feature I'll come to in due course, but I just thought it's noteworthy in the first instance. If I take you next to page 315, at paragraph 9, you will see in respect of Mr. Anthony Henry, they say it's a little less grim, and on the 26th of September 1995, he was a young man aged 20 who was arrested for a double murder and held on remand pending trial for 7.5 years until his arraignment on the 7th of February 2000.
Can I just check that?
Yeah, I don't think that's correct.
No,
that's not right, because it's roughly 4.5 years, I would think, give or take. Yeah, so it's not 7 years. That's correct, my Lord. And he was found unfit to plead, and likewise he was to be detained in the custody of Her Majesty's prison until pending the Governor General's pleasure, until it's known. And he remained there until he was discharged unconditionally by the High Court, sitting its criminal jurisdiction on the 30th of May 2019. In total, he spent 24 years. So that's the, in brief summary, that's the dramatis personae, as it were. Can I start by taking you to the relevant pieces of legislation and take it up at page 629 with the St. Lucian Criminal Code? And the criminal code has been, it was replaced, this is the 1920 version, it was replaced in 1957. Nothing much turns on the various incarnations of the criminal code because the relevant provisions remain the same throughout. For good measure, we put the original version in the supplemental bundle, and I'll come to that if needs be later. But it's the same, and there's no dispute between my learned friend and I on that.
But the original version was 1888.
That's correct.
Right the way back to that.
That's correct, my Lord. That is correct. So at 1019, at page 629, it reads, if any accused person appears before or upon arraignment to be insane. Can I just pause there? Because the word before caught my attention, which is why I raised it with the board up front, that, you know, the interregnum between when the person is arrested and detained and when they're arraigned and called upon to plea is a pretty substantial period of time that really didn't feature on the radar of the case in the courts below. But I'll draw it to your attention because I may wish to address the court on that matter, on the question of damages and, when I come closer to the end of my submissions. Now, my lords, so it says, before or upon arraignment to be insane, the court may order a jury to be empaneled to try the sanity of such persons, and the jury shall thereupon, after hearing the evidence for that purpose, find whether such person is or is not insane and unfit to take his trial. If during the trial of any accused, such a person appears after hearing of the evidence to that effect, well, that's just if during the trial they appear to be insane, you will return a verdict that such a person is insane. And then we take it up at next at 1021. At 1021, where any person is found to be insane under the provisions of 1019 or has a special verdict found against him under the provisions of the preceding section, the court shall direct the finding of the jury to be recorded, and thereupon the court may order such person to be detained in safe custody in such a place and manner as the court thinks fit until the Governor General's pleasure shall be known. The judge shall immediately report the finding of the jury and the detention of such person to the Governor General, who shall order such a person to be dealt with as a person of unsound mind under the laws of this state for the time being in force, for the care and custody of persons of unsound mind, or otherwise as he may think proper. My lords, a lot turns on the correct interpretation of this section, and my preliminary remarks at this stage on it would simply be to say that it's clear that the order to be made by the court is really a prelude. And it's a prelude to getting the Governor General to exercise his discretion. But what we say about this, notwithstanding the interchangeable use of the word may and shall throughout the section, is the object of the section. There can be no dispute that the object of the section is quite simply to ensure that the person, that the defendant, is housed in a suitable place where he can in fact be looked after and receive proper treatment. That's got to be the only sensible construction on a purposive reading of these sections that treat the persons who are of unsound mind.
But I mean, they might be extremely dangerous, say, to the public.
Indeed.
And I mean, I don't have detailed knowledge of the range of facilities available in St. Lucia, but it may be that having regard to the danger they pose to the public, actually putting them in prison under conditions of secure detention might be the most sensible thing to do with them, provided you put in place a package to assess and support their mental health. Yeah,
I'm glad, my lord, the rider is important, because the short point is putting them in prison on the basis that there are appropriate facilities to treat with them, to evaluate them and give them proper treatment and rehabilitation. That's the point I'm on. So even if one says that the power includes that as an option, or as he thinks, as he may think proper, is wide enough to give him that discretion, the short point is wherever he chooses to place them, a purposive construction of that power has to be that they're housed in a place that can cater for their treatment and rehabilitation, because they lack the requisite mens rea to commit, to be tried for the to be tried, as it were, until they're fit to be called upon to plead. And in those circumstances, one has to balance, yes, the security, but one has to bear in mind the presumption of innocence, which they're entitled to under the Constitution at that stage, the presumption of innocence, and that they are also in a vulnerable mental state. So that if we were to take it that the Governor General has an unlimited discretion and he's given a legislative carte blanche power to make any order as he might think proper, without reference to that end result in sight, then what happened in this case could in fact happen, which is that you end up serving a life sentence without any due process of law. Because make no mistakes about it, that is what, in substance and effect, they were serving a life sentence. And but for the intervention of Miss Lydia Faisal, who filed the claim on their behalf, they would have probably still been there. And that's the point. I mean, if however the law is to be on a proper construction, if they are placed in housed where they can have proper evaluation, proper treatment, proper psychiatric treatment, proper medication, and most importantly, periodic reviews to determine that the legal objective of determining whether they are fit to be called upon to plead so that the arraignment can be completed and thereafter to stand trial. I mean, that when you look at it in the ground, I mean, that's really the objective, and that's the way it ought properly to be interpreted. So we say that the power ought not to be viewed, it can't be looked at in a vacuum, or else it can, in reality, it can lead to what happened in this case, which is a virtual life sentence without any procedural safeguards intended by the Code and the Constitution. And if I go next, now to take you to the Mental Hospital Act at page, can we take it up at the supplemental bundle? The supplemental bundle, it is at page 7 to 9 in the first instance. And
I'm sorry.
oh, sorry, my lord.
No, not at all. Not at all. Can I just clarify things in my own mind? So, 1019 envisages a finding that the person's unfit, and paragraph 3 tells us that a verdict under the section is not to affect any subsequent trial in the event that he subsequently becomes of sound mind. So the possibility of there being a subsequent trial is obviously envisaged. And 1021, the court is to order the person to be detained until the Governor General's pleasure shall be known.
Yes.
But under 2, the judge is to immediately report the finding of a jury and the detention to the Governor General. So the order under under subsection 1 is a purely temporary measure.
That's correct.
Pending an order by the Governor General.
It's a purely interim measure. It's an interim order, I would say, my lord. Yeah. And that's why the language in subsection 2 is the judge shall immediately report the finding of the jury to the Governor General.
Yes.
So that the idea would be that it's an interim order, and you immediately report it and hand it over from thereafter to the executive in the person of the Governor General,
yes,
who will make an order, but an order, you know, that will be consistent with the legislative policy, theme and purpose of the Act.
Well, he's to be dealt with under the laws for the care and custody of persons of unsound mind. So in other words, the Governor General is to order the person to be dealt with under the mental health legislation.
That's what we say, and that's what the High Court found in this matter. And we say that is pellucid, and there can be no dispute about that. Mm-hmm. And we say the Court of Appeal got it wrong to find that there was some irreconcilable conflict between this and the Mental Health Act, such that there was any room for introducing the doctrine of implied repeal.
Yes.
Yes.
So if one's looking for regulation of the duration of the person's detention and the circumstances in which the person can be discharged, the place one would expect to find that is going to be the mental health legislation.
That's correct. That is correct.
Okay.
Much deeply obliged, madam. So if I can take you now to...
Sorry, just to make
sorry,
absolutely
yes.
sure we've got the structure right. We see at the end of section 1021(2), or otherwise as he may think proper. So
Yes.
He's required, the Governor-General is required to treat the person in accordance with the mental health legislation,
Yes.
because he does have a discretion to do something different. But as I understand it, you say that discretion was never exercised in this case.
Yes.
We're left with the default position.
That's correct. On the facts of this case, a lot of these questions, a lot of these permutations do not in fact arise for consideration on the facts of this case, because none of this actually happened. The government, there's no evidence that it was reported to the Governor General, or secondly that he purported to exercise any discretion conferred by the code under section 1021(2), so that it's really is a moot question. But in the event it were to be reported, we say he would have been bound to act in accordance with the Mental Health Act. I accept my Lord Sale's point that he would have also had maybe some residual discretion. But I say, even then, if for good reason one were to, the Governor General were to have a desire to house a person of unsound mind in a non-medical hospital, in any other form of facility, it would have to be that they've got the relevant treatment facilities, evaluation, rehabilitation, and so forth. It can't be that you can put them in a prison. What I say for sure is clear, is that he simply can't exercise the discretion to put them in a prison facility without any periodic reviews, without any proper evaluation as to what its capabilities are in relation to treatment of an insane person.
Yes, thank you.
Yeah. So if we can turn now to the Mental Hospital Act, and I said it's in the supplemental bundle, and if I take it at 1895, at page 7 to 9,
and I'm sorry, that last submission you're making, I think if you're looking for a legal analysis, you'd be saying that the discretion conferred by 1021(2) has to be exercised in conformity with the Constitution.
Yes.
Well, to say the least. And
well, it would have to be exercised in conformity with the Constitution, because there's a presumption of innocence, and this is a stage before they have been even called upon to plead. Secondly, it will have to be exercised in accordance with the policy and scheme and purpose of the Act.
Yeah.
And we say that is to rehabilitate the person, to restore them, so that they can be called upon to plead and then be tried.
I wonder. I mean, if the default position applies and the Governor General orders the person to be dealt with as a person of unsound mind under the laws in force for the care and custody of persons of unsound mind, then I wonder if criminal trial is any longer an issue. The person's being dealt with as somebody who is mentally ill.
Well, my Lord, I think the short answer is that's why we say it's a means to an end, and the end is he is in the criminal justice system. He has been arrested, he has been charged, and he has been detained. And all those three steps place him in the criminal justice system. And I don't think that, respectfully, my Lord, that 1021(2) is a power to pluck him out of the criminal justice system, such that he will no longer be liable to be prosecuted in the public interest. I think if, for example, one were to get a psychiatric report saying that, look, this person is permanently, irretrievably ill mentally, and they're a danger to society, and it's impossible to get that they will ever recover their full possession of their mental faculties, such that they can ever plead or be tried. Then in a case like that, I can see in an exceptional case that the power can be exercised to pluck them out of the criminal justice system. But until such time as you reach that stage, I think they remain in the criminal justice system, within the procedure.
The person remains subject to a criminal charge. He's been arraigned on a charge which hasn't yet been determined. But the mental health legislation has got nothing to do with criminal unless we find something contrary.
Yes.
One would think that it's likely to have nothing to do with criminal procedure.
Well, my Lord, the way we take the view that it does have some relationship insofar as the object of the mental health legislation, in respect of a person who is charged, is to see if you can rehabilitate them by treatment so that they can in fact face prosecution.
We'll come to look at it, but he's just dealt with by statute as a person of unsound mind.
Yeah, I see the point, my Lord.
Is he not just a patient who will be treated appropriately and discharged from the hospital if he recovers? And so far as the trial is concerned, is that not a separate matter for the prosecutor to keep under review?
Well, I mean, when we say discharged where?
From hospital.
Sorry?
From hospital.
Yeah, but to where? I mean, if he's discharged from the hospital, to where? And my answer is he'll have to be discharged back to prison and then be brought back before the judge.
What warrant is there for his imprisonment?
Sorry?
What warrant is there for his imprisonment?
I suspect, my Lord, the fact that he remains subject to a criminal charge, and that his detention is, as it were, it might be a continuing detention pursuant to that charge that was preferred.
But a person, he can only be imprisoned if there is a warrant committing him to prison.
Well, I presume that's why he's put in prison in the first place pursuant to a warrant for his arrest and imprisonment. So yes, and I think that the process that is set in train by virtue of that warrant for his arrest and charge, it continues. And that's why I say if he regains full possession of his mental faculties, then he goes back into the regular system. He goes back into prison. He's brought before the judge, and he's called upon to plead. He either pleads guilty or not guilty, as the case may be, and the process continues.
I wonder if he recovers his senses, if his health is restored, would be a better way of putting it. If his mental health is restored and the prosecutor considers that he should be remanded in custody, does an application not have to be made to the court to remand him in custody?
Well, I suspect my answer would be this: if he's put back into released back into prison, and he's taken before a judge, at that stage several things will have to happen. One, depending on the length of time it took for him to regain his senses, as the case may be, you may have an application for a permanent stay on the basis that there's obvious presumptive prejudice having regard to the lapse of time, and it will be unfair to continue with the prosecution. You may, for example, have an application for bail based on the reports from the mental health hospital saying that, look, he's a great guy now, and he ought to be given a chance. You might have a biosocial report from the probation department. A number of things may come into play. But the point I'm making is, I don't see it, respectfully, my Lord, as an opt-out from the continuing criminal justice process that has been set in train by virtue of the charge and the detention pursuant to that warrant for his arrest and detention.
It's not an opt-out, but I think the point in your favour is it's not an adjunct to the criminal process. It's a separate regime for mental patients. It's the point I think being made.
Yes, that is the point being made.
Yes.
and that you have a different way of dealing with somebody who's mentally ill from punishing them for a crime they've been convicted of. It's as simple as that, really.
Yeah, but fair enough. I mean, the short point is, my lord, look, it's either they remain continuously liable to the criminal process, or if we interpret it as the state seems to suggest, that otherwise, as he may think proper, gives him an unlimited discretion, including that the executive, the Governor General, in this second limb, he is exercising powers in his capacity as the representative of the executive, and insofar as he exercises that executive discretion to say, well, look, we take him out. It's a parallel procedure, and he is now placed in somewhere where he can be rehabilitated, and thereafter he's not liable to the criminal process. Well, then, as my lord has rightly pointed out, then that favors the appellants in a much stronger way. But I do say that I think, I think the former, is worthy of equal consideration, as the case may be.
And apart from there being separate processes, the other point I was trying to explore with you was that the fact that somebody is subject to a criminal charge doesn't necessarily mean that they're held in custody.
No.
There has to be, in the first place, an order made by a court, and the court can either remand them in custody or it can remand them on bail. Now, when this person is under this regime, when the person when the jury has reached this verdict, or the person has been arrested, I can't remember if in our cases the jury did reach a verdict, but when he is found to be unfit to stand trial, the court, as we've just seen, makes an interim order.
Yes.
It doesn't make any permanent order, either remanding him on bail or remanding him in custody. It simply makes a temporary order, and the Governor General then makes an order for him to be dealt with under the mental health legislation.
Yes, I understand.
So once if the mental health treatment comes to an end, and he no longer has to be kept in hospital and is able to be discharged, then I would have thought he'd be entitled to his liberty unless an application were made to the court in the criminal process for him to be remanded in custody, pending trial.
I suppose, unless the DPP re-indicts or issues a fresh warrant for his arrest, as the case may be. I appreciate that. I mean, the reason I hesitated, my lord, is because, I noticed one of the appellants before you was charged with murder, and in many Caribbean countries that was a non-bailable offence until the board's judgment in Achille Charles. So there are permutations to consider in terms of whether the court would have to make an order for the continued detention, depending on the nature of the offence, for example. But I accept the point.
Well, even people accused of murder are only held in custody, at least in this country, are only held in custody because of a court order remanding them in custody.
Indeed. So my lord, on either analysis, there was no lawful justification for the detention, the continued detention of these appellants, which lasted for decades, on either analysis. Can I go to the Mental Hospital Act, which we'd find at in the supplemental bundle, and I'll take it up at page 7, just to make a brief observation that. It would appear that court is defined at page 6. This is at page 7 of the supplemental bundle. It's 1620 at the bottom. And court is defined as a judge of the High Court. And I make that point because when you look at sections 3 onwards, it really it speaks to the power of a magistrate in the context of dealing with someone who is suspected to be mentally insane. without any reference to the criminal process, without him being charged or for any offense as the case may be. But when we come to the High Court, we go to page 15, section 30. And we see at section 30 that the Governor General may appoint the whole or part of any building, prison, hospital, house, or other place, premises there to be a mental hospital for inmates. Now, this issue did arise in the courts below, and I think it was agreed that this power was never exercised by the Governor General in relation to this matter. But I pause simply to note that the logical inference and implication of that not having been done, it seems to me, would be that the prison was not in a state where the Governor General felt that it had the necessary. It would be a proper place for to act as a mental hospital for inmates. And then at section 31, we are told, and we say that this section should be read together with the section of the Criminal Code, that 1021. And in section 31, it says, if any person upon arraignment before the High Court in its criminal jurisdiction. Now I pause there simply to point out, my lords, that because the court here is defined as the High Court, and because upon arraignment, it says upon arraignment before the High Court, and because the period of the intervening period was 4.5 years, it literally means that in St. Lucia, the procedure is such that the magistrate, apparently you're not called upon to plead. There's no arraignment before the magistrate. You're not called upon to plead before the magistrate. You're only arraigned before the High Court and called upon to plead at that stage. So all the magistrate deals with in the first instance is the question of bail. Now, there is a certain amount of discomfort over the fact that people can spend such a long time until they're arraigned before the High Court. But in any event, upon arraignment before the High Court, during his or her trial for any offense, or during his or her trial for any offense, is found by the jury to be insane, the court shall order that the trial of such a person be postponed until he or she becomes of sound mind, and in the meantime, he or she be detained in custody in such mental hospital as the court appoints until Her Majesty's pleasure is known, and thereupon the Governor General, on behalf of Her Majesty, may give such an order for the safe custody of such a person until he or she becomes of sound mind as the Governor General thinks. If any person charged before any court with any crime or offense appears to the court to be of unsound mind, and it's not practical, and it shall not be practical to hold an inquiry, it is lawful for the court to order such person to be detained in custody in a mental hospital, which for this purpose shall be deemed to be a prison until an inquiry can, with reasonable expedition, be held. Now, my Lord, that's where the means to an end, we say, comes into play. And we say that this section ought to be read in conjunction with the Criminal Code. And it's clear that insofar as Parliament prescribed, all Parliament did here, there's no room for the doctrine of implied repeal. All Parliament was doing is prescribing a place to which a person of unsound mind can be placed, or should be placed, as the case may be, if one accepts that the Governor General has, as my Lord Sears has pointed out, a residual discretion. But the Court of Appeal, in our view, fell into error when it invoked the doctrine of implied repeal on the supposition that there was an irreconcilable conflict between the two sections. It just doesn't arise, we say respectfully.
Yeah. Can you help us with why in section 31.2 a mental hospital is deemed to be a prison.
Yes, I think the reason for that is the point I made earlier, which hence my reluctance to agree, in that you're not taken out of the criminal process. You continue to be detained pursuant to the initial warrant for your arrest and charge, and that's why I think it deems it to be a prison, and that's why I was a little reluctant to agree with my Lord Learned President to say that that option B is there. I mean, it seems to me the wording of the legislation suggests that they continue to be subject to the criminal process.
Could it be because if the person is later found to be fit to plead and is then convicted and sentenced, that the period spent in a mental hospital can count towards the sentence?
Yeah, that makes sense, my Lord. I'm grateful. Yes, it would obviously make sense to say that it could be as well that pre-trial incarceration would be taken. You would be able to take it into account when dealing with the question of sentence. Yes. Yes. I mean, at that point, one doesn't know whether he's unfit for trial at that point as well. So it's pretty early in the day.
Yes.
Yeah.
I mean, 31(1) is giving the court a power to order detention in a mental hospital.
Yes.
But that's conditional on a jury finding that the person is insane.
Yes.
Whereas subsection 2 is proceeding in the absence of any such finding.
Yes, because it's not practicable to hold an inquiry. Yes.
Yeah.
Yeah.
So the regime is that once it has been determined that the person is insane or not of sound mind, then they're to be, in principle, sent to a mental hospital and not a prison.
Yeah, that's the short point. And we say that's pellucid and unarguable in terms of the plain and literal meaning of the sections.
And clearly there is a difference between what's laid down in 31(1) and what's laid down in 1021 of the Criminal Code.
Yes.
Which one takes priority?
Well, my Lord, we say they should be read together, but insofar as the Criminal Code predates the Mental Hospital Act. So insofar as the Mental Hospital Act, the Criminal Code came about in 1888. There have been various incarnations, but the relevant sections, for the purposes of this case, remain the same throughout. And the Mental Health Act came along 7 years later in 1895. And insofar as the later in time Act can be read together with those provisions, we say that these provisions ought to be applied, my Lord.
It can't really be a question of which comes first, can it?
No, we say they should be read together.
The more significant point is that the two are capable of being made to fit together.
Yeah, well, that's what we say, my Lord. They're to be read together, they complement each other, but there is no irreconcilable conflict to give rise to the doctrine of implied repeal. That's what we say. Now, can I go next to page, if we go back to the electronic bundle, and we go to the prison ordinance at page 650. And the prison ordinance at page 650, we have section 28. And this reads as follows. Whenever a person detained in a prison or lockup is awaiting trial or is remanded in custody, and it appears to the administrator, acting in his discretion, on the certificate of a registered medical practitioner, that such a person is of unsound mind, the administrator, acting as aforesaid, may, by order in writing setting forth the grounds of belief that such person detained is of unsound mind, direct his removal to the mental hospital, there to be kept, and treated as if such person had been ordered to be detained in such mental hospital, under the Mental Hospitals Ordinance, and until the medical officer of such mental hospital certifies that such a person has ceased to require treatment in that institution. Wherever the medical officer has so certified, the administrator acting in his discretion shall by order in writing direct that such person be returned to the lockup whence he was removed, there to be dealt with according to law. So what we say here is that, again, notwithstanding the purpose of it, consistent with the interlocking pieces of the Criminal Code and the Mental Hospital Act, the purpose is to have treatment, and if the person is properly treated and rehabilitated and they cease to require treatment, they are returned to the lockup from where they were removed to be dealt with according to law. So, I mean, I don't know if that elucidates the earlier, shed some light on the earlier discussion we had. Now, and this applies to persons who are on remand awaiting trial, and not necessarily, as it were, convicted prisoners. Can I take you next?
But in our case, under Section 31 of the Mental Hospital Act, the court, on your submissions, I understand it, the court ought to have made an order for the appellant's detention in a mental hospital.
Yes.
And should thereafter have been an order made by the Governor-General.
Yes.
But in reality, the court didn't make such an order, and the Governor-General didn't make any such order either.
That's correct.
Yeah.
That's correct. And we say, therefore, the detention was completely arbitrary, without due process, and in breach of his constitutional right not to be deprived of his liberty except by due process. Now, this is the consistent golden thread that runs throughout the legislation. I mean, the Correctional Services Act 2003 had repealed the Prisons Ordinance, and I take you to page 627 to see what that says briefly. At page 627, section 24, and it says, where a person detained in a correctional facility, lockup or legalized police cell appears to the director or the person in charge of the lockup to be mentally ill, the director or person in charge may order the consultant psychiatrist to examine the person detained. Where the consultant psychiatrist certifies such a person detained is, in his opinion, mentally ill, the director shall seek a court order to have the person detained committed to a mental hospital and there to be kept and treated as if he or she had been ordered to be detained in the mental hospital under the Mental Hospitals Ordinance until a consultant psychiatrist certifies that he has ceased to require treatment in that institution. The court, which made the order for committal under subsection 2, shall direct the person detained to be returned to the correctional facility, lockup, or police cell where he or she was removed, there to be dealt with according to law. So, my lords, we have dealt. Yes. So we say that the treatment of the person of unsound mind it's really the end result is until he or she becomes of sound mind, and you will see that at the end of section 31 in the Mental Health Act, where it says until he or she becomes of sound mind as the Governor-General thinks fit. And it's also where the court shall order that the trial of such person be postponed until he or she becomes of sound mind. So that it's so the whole purpose of the statutory regime, it's all geared towards until such time as the person can become of sound mind, so that they can continue with the criminal process. That is how we interpret it. Now, my lords, In the interest of time, we have dealt with this in our written submissions in the case for the appellant at page 569 at paragraphs 17 to 24. And I will just give that reference. And in terms of our analysis of the various, the intertextual analysis and the interlocking provisions to which I've referred. And can I move on to the question of implied repeal, just to touch on it briefly?
Just to be clear, the prison ordinance, section 24, no longer applies, is that right?
That's correct, yes, because the prison ordinance was repealed by the Correctional Services Act of 2000.
Sorry, it was repealed by the
Correctional Services Act 2003.
Right. It's the prison ordinance that no longer applies. Thank you.
Yes. So what we say, my Lord, the short point is that as of 2003, even then, it is clear as to what should have happened as of 2003, and none of that took place either. And the reason we've cited all these provisions is because the duration of the incarceration spans the gamut of these various legislative enactments. So that, but in any event, absolutely nothing. There was no compliance with any of the legislative provisions. Now, in terms of the question of implied repeal, I think we have, I've already addressed my lords on that, but part of the reason it doesn't make sense with respect to the Court of Appeal to suggest that that doctrine is arises on the facts of this case is that firstly they got it wrong to say that the code came after, because the criminal code was first enacted in 1888, and the Mental Hospital Act, sorry, came 7 years later in 1895. So that's a first error. And secondly, if one were to take the position that the subsequent enactment somehow impliedly repeals the first, well, what you do have is the criminal code was enacted and reenacted at various points in time, and what you'll have is a bit of a bit of a legislative ping pong ball match, with one cancelling out the other, until you get that the criminal code remains triumphant. We say all these two provisions do is that Parliament was prescribing, what is a safe and sound place to which the Governor-General or the court can place a person who is of unsound mind, i.e. a mental hospital. And there's no irreconcilable conflict that arises to give rise to the doctrine. In terms of next, the failure to treat with the issue of periodic reviews, if I take it at page 463 of the electronic bundle, at paragraph 62 of the Court of Appeal's judgment, this is what the court says. I agree with the submissions made by Mr. Patterson, Queen's Counsel, in that in order to find that an unreviewable detention has given rise to a breach of a constitutional right, the court must be satisfied that the detained person was prejudiced by the failure to conduct reviews. In my view, a detainee would have to show that had periodic reviews taken place as required, the result would more likely than not have been that he or she would have been permitted to stand trial or have been otherwise released from detention, and therefore that there was some connection between the failure to conduct periodic reviews and the continued detention of the detainee. In other words, a detainee would have to show that at the very least it was more likely than not that they recovered their fitness to plead, and therefore, taking into account all of the other relevant circumstances, their continued detention amounted to inhuman and degrading treatment. None of this evidence was before the learned judge. It could therefore not be said that the sole fact of the respondent's detentions, having been unreviewed, could have given rise to a finding that the respondent's detention on the ground of unfitness to plead could amount to inhuman and degrading punishment. And then at page 472, paragraph 81, the learned Chief Justice fleshes her reasoning out by saying, however, I am unable to see, 3 lines down into the paragraph 81, I'm unable to see how in this case such a breach could be made out on the evidence. Again, there was no evidence which could tend to establish that either of the respondents ever assumed or recovered fitness to plead while detained. On the contrary, the uncontroverted evidence before the High Court was that both respondents continued to suffer from serious mental illness up until the time they were last assessed by the state psychiatrists. No prejudice could therefore have arisen from the fact that they had not been subjected to periodic reviews to determine whether they were fit to plead and stand trial. It follows then that the respondents' unreviewed detentions could not amount to a breach of their rights to liberty, as no argument could be made on the evidence that they would have been released, whether on bail or otherwise, had they been subject to periodic reviews.
The question whether someone was continued to suffer from a serious mental illness is not necessarily the same question as to whether they were fit to stand trial.
Indeed.
Someone could suffer from a serious mental illness and still be competent to understand the proceedings, for example.
Indeed.
The argument seems to be that you're only entitled to have a review to see if you're fit to stand trial if you can prove that you would be fit to stand trial were to there to be a review.
Yes, and that's the point. It's it doesn't take us anywhere, and we say that the court erred to adopt such an approach. It's a circular, syllogistic argument that just doesn't take us anywhere.
I mean, I think one needs to bear in mind the 2 contexts in which these paragraphs appear. So the first one is in the context of a discussion of inhuman and degrading treatment.
Yes.
The second is in the context of the right to liberty.
Yes.
Which are you addressing us on at the moment?
Well, my Lord, what I say is that on whichever ground, we say that the facts of this case gave rise to a prima facie case that was made out against the state. And if anything, the evidential burden would have shifted onto the state to provide evidence of these matters if at all was required. But to say, as the learned Chief Justice said, that look, we needed to provide evidence that we would have acquired, we would have regained our senses, to use the learned President's term. We would have regained our senses, and therefore the real prejudice would have occurred. We say it's just not on. It's a highly, with the greatest of respect, a highly unreasonable evidential burden and request to make of the appellants.
But, I mean, in a sense, do you, for the purposes of your appeal, do you actually need the point based on Section 5, inhuman and degrading treatment?
No, I'll come to...
If you win on breach of the right to liberty, isn't that a sufficient foundation?
My Lord, I'll come to that, and the short answer is I agree, no, I don't. The short answer is no, I don't.
Right, thank you.
So, my Lord, on the periodic review, and I'll come to that, my Lord, it's soon. So on the periodic review, we say at page 578 of our written case, we've dealt with the point, and we say that the High Court, the trial judge, got it right on this point, and that it really would. In any event, even if on the issue of the absence of periodic reviews doesn't convert an illegal detention into a lawful one, it might have given rise to having a bearing on the question of damages at most, but it couldn't have any bearing on the question of whether the detention was lawful. Because that comes post the detention, during the course of the detention, and we say that it was for the state, if anything, to produce evidence about that. We couldn't disprove a negative, as the case may be. On the issue of the inhuman and degrading punishment, as my Lord Sales has raised the point, we say as follows: we support the finding in this regard But it doesn't have a direct bearing on the unlawfulness of the detention and the deprivation of liberty. We see it more as the judge, in the exercise of his discretion, taking this into account in the need to vindicate the importance of the fundamental rights and to express some sense of, and reflect some sense of outrage as to what transpired.
It's a different right.
It is a different right, yes.
And in order to show a breach of it, you've got to look at the actual treatment itself, haven't you, and the conditions in which someone is held.
Yes.
The fact that it's an unsuitable place does not itself make the treatment inhuman and degrading, does it?
No, I accept that, my lord. I accept that, and what we've submitted in our written case is that that's one line of established authority, but that the mere fact, in certain exceptional cases, the mere fact that an order has been made with such drastic consequences for innocent persons might give rise to an appropriate finding that this particular right was breached. And we say that the Court of Appeal adopted too narrow an approach. This is not a case where we accept. This is not a case where the minimum severity threshold was met by reference to the evidence per se in terms of how they approached it. That is not, we're not conceding that there is insufficient evidence, but what we do say is this. If I take, if we go to page 579 of the written case, we say that the Court of Appeal took too narrow a view of what constitutes inhuman and degrading punishment. And we say that in paragraph 66, the simple fact of the treatment chosen or imposed, or the process by which it is chosen or imposed, may properly be said to be inhuman or degrading treatment, without the need to consider or compare, as a question of degree, the actual conditions of the treatment. Bear in mind that all of the cases that deal with the severity of the treatment point are cases where the detention was lawful ab initio. So that in this case here, we say the detention, the detention is not lawful, and it's therefore possible to distinguish it.
You seem to be saying that that if you're falsely imprisoned, then you get sort of automatic inhuman and degrading treatment as a bolt-on to that.
Well, no.
That can't be right.
Well, my lord, no, that's not
They're
what we
quite
say.
separate rights.
Yes, I accept that. What we do say, my lord, is that this is an entirely exceptional case, and we say that the
well, it's a severe breach of one right doesn't convert it, into a breach of another, does it?
Not necessarily. No, I accept that, my lord. Yes, but what we do say, just for the record, my lord, what we do say is this: the appellants. We say that since the High Court found that the appellants ought to have been detained in a mental health facility and given treatment, but were instead kept in a prison, and although that they were not convicted of any crime, and they couldn't stand trial unless there were periodic reviews that were geared towards determining their fitness to stand trial, this case amounts to no more than indefinite life imprisonment because they were mentally ill. And we said that by itself, that statement by itself, it ought to cause a certain amount of trepidation and alarm, such that the judge cannot be said to have been plainly wrong to say that that in the exceptional case that was before him, that it would trigger his concern to vindicate this particular right.
But I understood you to accept, Mr. Ramlogan, in response to my Lord Legate's question, that the fact that the location where a person is detained is an unsuitable place doesn't make it inhuman or degrading treatment.
That by itself, no, I can't accept. I have to accept that, my lord. Yes.
So what else is there here? Because there's the fact that you may have succeeded on an independent point,
yes,
on right to liberty, but there's no evidence about the conditions.
Well, Lord, I shan't press the point. I shan't press the point. It's our submission is that in human treatment is not always a matter of degree. That's not an absolute rule. There must be, in the exercise of judicial discretion, in an appropriate and exceptional case such as this, as we've outlined, there must be room for judicial discretion to say that on the facts of this case, where all of the legal safeguards were simply bypassed and they were arbitrarily detained without any hope in sight for judicial intervention or remedy, that they were serving a life sentence without due process. And in those circumstances, regardless and quite separate and apart from the conditions, what we do know about the conditions is that the Governor General did not see it fit to designate the prison as a mental hospital. We do know that there were no periodic reviews. We do know that the judge didn't notify the Governor General to exercise any discretion. In other words, there was a complete collapse of the rule of law in relation to these two appellants. And
then your argument comes back to saying that it's a very severe deprivation of liberty, or very arbitrary. That makes it breach of a different right. And I thought you accepted that can't be correct.
Well, no,
matter of analysis.
What I accepted, my Lord, is that in the absence of what I accepted is that on the issue of the evidence as it relates to conditions of detention, I accepted that that's, the evidence is there's less than satisfactory evidence in relation to that. But that's if you adopt the minimum severity approach. But what we are advocating is a different approach. We say that...
You seem to be advocating that if deprivation of liberty is particularly arbitrary, then you also get a breach of inhuman, degrading right not to be treated with human degrading treatment thrown in as well. Well, there must... That's completely...
Well, there must be a certain level when a certain time when the level of oppression that comes with that, where all of the procedural safeguards that are designed to protect a vulnerable person like this would trigger something more than just a mere deprivation of liberty. I noticed that the judge did not in this case award any vindicatory damages, and that's why when I take it to his judgment, I think that this was more on his judicial radar as operating in the realm of part and parcel of the vindication of the fundamental rights triggered. I mean, what he said, in fact, in his judgment is that it amounted to criminalization of the mentally ill. And we say that takes it's an extraordinary, an exceptional case. And we say that the board ought not to disturb that finding of the trial judge in relation to the infringement of this particular right. Bearing in mind that the preamble to the St. Lucian Constitution speaks about, the importance of the human right to human dignity and all of that, and the preamble gives inspirational force to the text of the Constitution. But in the alternative, if I may just move on from that point.
Isn't the right to liberty important enough without you having to try and manufacture it into something else as well?
Well, save and accept that you can be deprived of your liberty in a way that doesn't necessarily deprive you of your dignity. And we say in this case that the deprivation of liberty went so far that it affected the very essence of his human dignity. These men, but for the fact that Ms. Faisal intervened, as an officer of the court, these men would have still been in prison. We're talking about decades. And you couldn't have a more exceptional case. I mean, this case, these were vulnerable persons who the law specifically made specific provisions for their protection, and you had a complete collapse of all of those procedural safeguards enacted by Parliament, and they were just lost in the woodwork of the prison system.
One does need to be a little bit careful. They were being visited and assessed by psychiatrists periodically, at least from 2003.
Yeah, but to what end? You see,
but if you're looking in terms of are they being treated humanely, one might think that they are being treated humanely because arrangements have been made to put the appropriate medical personnel in place to assess them and help them as best they can.
Well, I accept that that might be a point in mitigation, but I don't accept that the intermittent and sporadic visits of the psychiatrists which were not geared towards, which were not in compliance with the legislative purpose and scheme and policy of the provisions, which was designed to assess, to rehabilitate them, treat them with the end result of putting them so that they can be fit to plead or fit to face trial. But that's just not, it's just not enough to pluck that arbitrarily and to say, look, outside of the legislative scheme, they were being seen by persons on a very intermittent and sporadic basis, and that somehow gives some element of compliance with the rule of law. But can I, in the alternative, say this, my lords? What we do say is that in any event, if I can take you to the judge's reasons, just to briefly show you what the judge said, and it's at page 335. At paragraph 62. The judge said, the trial judge said, look, I think the approach in the circumstances of this case should be to award damages based on my finding that they were deprived of their personal liberty in a manner that was not authorized by law. Where a claimant seeks damages for breach of the right to a trial within a reasonable time, what he is seeking to vindicate is his or her right to personal liberty to not be kept in prison awaiting trial longer than can be reasonably expected. Similarly, the award of damages for the failure to conduct periodic reviews of a person's fitness to stand trial is ultimately directed at vindicating personal liberty. And then at, if I take it next to page 3, if we scroll down to the next page, we see the declarations. And this is how he approaches it. The first one is a declaration that the state's detention of the claimants in prison after being found unfit to plead due to mental illness instead of in a mental health facility is in breach of their right to personal liberty. And I ask the court to note that it's all hinged and linked to after they were found unfit to plead. In 2, the state's detention of the claimants in prison instead of a mental health facility after being found unfit to plead due to mental illness without periodic review, breach of the right to protection against inhuman and degrading punishment, and reduces their inherent human dignity.
Just in relation to after being found unfit to plead,
yes.
Isn't that because the claim based on Section 3 is founded on the rubric save as may be authorised by law, and the argument, as I understood it, was that once they've been found unfit to plead, there are legal provisions which were not followed, and that's the foundation for the violation of Section 3.
Yeah, well, that's why when I took the court through the provisions, you would have seen that the law does admit the possibility of this happening before arraignment. I think Section 28 of the ordinance uses the term before.
That's not this case.
No. Well, my lord, what I say is this: the relevance of it is this. If one takes, for example, the inhuman and degrading punishment point, or any of the breaches, the short point I make is this: when the appellants appeared before the magistrate the first time, on the state's case, these people were always of unsound mind. And the respondent can't blow hot and cold at the same time. If they were always obviously of unsound mind, well, when they appeared before the magistrate, can we really say that they ought not there and then to have been referred, to the High Court for them to for a jury to be empaneled to determine their fitness? I mean,
that's a separate complaint that hasn't been made in this case. It could have been made even if they had been found fit to plead, that they'd had to languish in custody for 4.5 years, and that was too long. That isn't what this claim has been brought about. You can't just bring it in now on a second appeal.
Well, no, I accept that. But I make the point as a footnote simply because on the question of damages, on the appeal against the award of damages, I say this, my lord.
But you don't get more damages for the good point just because there's another one you didn't make.
No, but what I say is this: insofar as the question of damages the board has been asked to review the award of damages, then it leaves this as an open playing field for this point to be taken into consideration in saying that we should uphold the award of damages because
That's hopeless. You can't justify an award of damages for one ground on the basis there was another ground you haven't made in the case and which hasn't been determined in your favour.
Well, I'm not, insofar as the judge felt it necessary to vindicate the rights that were involved, and insofar as the right to personal liberty is what was an issue in the case, we say that this is the point that if the board is minded to engage its jurisdiction to review the award of damages, it's a point that that the board can properly take into account as a relevant.
Why is it relevant?
It's relevant because for 4.5 years they were.
But you've just accepted that you've got no claim that was unlawful.
Well, my Lord, it's relevant because it's obviously unlawful, and we are dealing with the deprivation of liberty. And insofar,
Now you're just trying to start. You're just doing exactly what you said you weren't, which is to try and bring in a new ground, not argued in the claim form, not part of your, not argued in the Court of Appeal, not in your written case or grounds of appeal, and suggest that we decide that question now and justify an award of damages for something else on the basis that actually this was a good point.
And
Surely you've been hearing here for long enough, Mr. Ramnogan, to realise that that is an untenable approach to take.
I'm guided, my Lord. I'm guided. I accept the novelty of the point is novel at this stage. My Lord,
can I take you back, Mr. Ramlogan, just for a moment?
Sure, my Lord.
You were encountering some robust challenges to your argument about inhuman and degrading treatment.
Yes, please, my Lord.
You haven't referred us to them in your oral submissions just now, but in your you have produced, I think, one of the Strasbourg judgments concerned with life without parole. Now there the sentences.
Yes.
Although sentences of life without parole have been held to be inhuman and degrading treatment for the purposes of the European Convention, although there is no unlawful deprivation of liberty, but they are held to be inhuman and degrading treatment because, for two reasons, I think. One is that the detention is viewed as lacking any penological justification. And the other is that the person is deprived of any hope of release. And as a matter of psychology, that's regarded as an inhuman way to treat people. And you're dealing here with people who are kept in prison for decades with, I suppose you would argue, equally little justification and with equally little hope of ever being released. And I suppose you would add in as a factor there the fact that these people are also mentally ill. And so you're asking us to make an assessment of that amounts to inhuman treatment.
Indeed.
And so, I mean, what I'm trying to help you with really is that you're not, as I understand it, simply saying that deprivation of liberty, if it goes on long enough, automatically amounts to inhuman treatment. But you're saying that in this case it had particular characteristics which rendered it inhuman, and you say that's a position which you rely on the Strasbourg authority to support you in taking that position.
Well, that's correct. And we've dealt with this at paragraphs 70 and paragraphs 75 of the written case. And we've made the point that there is no penological justification for the detention. We've cited the case of Winter. This is at page 580 at paragraphs 70 to 75. And we've, you know, we do support the trial judge's finding on inhuman and degrading treatment for those reasons, and we've summarized it at paragraph 73.
Yeah, yeah. Thank you very much.
And so we stand by those submissions.
Sorry, just on paragraph 75, you say there's no prospect of them being found to have sound mind without periodic review. But just going back to the point I raised with you before, if they're being assessed by psychiatrists
Yes, please, my lord.
from time to time, there is a prospect that they might be found to have recovered. It may be that that assessment is not geared to whether they're specifically recovered with a view to participation in a criminal trial. But it's possible that due to treatment or just changes in their condition, that a psychiatrist would identify you're no longer suffering from mental illness and you don't need to be detained for treatment.
But what I say to that is that there would have needed to be strong evidence from the state to the effect that, look, the sporadic visits and the treatment they were receiving were in that context, and that the facilities that were available for the treatment of these persons were such that it would have been appropriate to give rise to the prospect of their rehabilitation, to be able to regain their senses and you know, be fit to plead and stand trial. But there is no such evidence, and it is highly, it would amount to, in my respect for submission, unjustified speculation to fill that breach or that omission, that evidential omission on the part of the state. Yeah. Now, my lords, on the issue of damages, I mean, one has to bear in mind, my lord, that, I mean, if we're dealing with persons who have unsound mind, I mean, in one of them, when we look at it, he says in the affidavit, well, you know, his memory was fading and his memory would come and go. So it's a bit unreasonable, unfair to expect that they would give evidence about the, you know, the context of the treatment, the purpose of it, the kind of facilities that are available. To put that burden, it's a bit unfair and unreasonable. If I take you to page 1120 of the record, this is the case of Michael Stevens. It's it's as close as the judge could have gotten, because it was a case where this was insane. I think it was a verdict of guilty but insane.
I'm sorry to interrupt you, Mr. Amlogan. Did you say 1120?
Yes, on the electronic bundle, 1120.
This is partway through a judgment.
Oh, it says,
Yes. Oh, sorry, I beg your pardon. It begins at 11:05, my lord.
That's fine. I've got it in front of me. Thank you.
Obliged, my lord. And guilty but insane.
For some reason, I won't respond. I can't get 11.
Oh, I see. Sorry, my lord.
Is it not doing anything?
Can you get it? No.
Is that?
Carry on. I'll listen and make a note.
You might have to switch it off and switch it on again. I think you'd better just carry on, Mr. Amlogan. Lord Lloyd-Jones can make a note.
I'm obliged. So what we see here is, in this case, the approach taken by the judge in this matter was that in paragraph 50 it says, as to the actual figure for the award of compensation per day for the infringement of the constitutional right, he says there appears to be wide variance, and he concludes that paragraph, having reviewed some authorities, he said the court will use the average of $100 per day. With respect to the general damages for common law unlawful detention, he says he cites Everett and Davis for a good summary of the distilled principles, and without consideration of job loss or prospects, and he says the court will use an average of $500 per day for the general damages. Now, what I find interesting in this case is that the judge he separates the award of damages for vindicating the constitutional right as opposed to the mere loss of liberty simpliciter. Now, I make that point because insofar as the board should respectfully only intervene if the award of damages is so unreasonable and manifestly high that it's outwit the bandwidth of reasonable options that would have been available to the High Court judge. And we say we don't get there because the judge in this case didn't, in fact, treat with liberty separately, from the need to vindicate the constitutional rights. And if I take the court to page 1124 of this very judgment, in the relief, you will see at relief number 3, he awarded at $100 a day for the breach of the constitutional right to liberty, and then he awarded general damages for the unlawful detention at $500 per day. I simply bring this to the board's attention only because, and I noticed that he gave interest from the date that the claim was filed. Now, those three things, if I compare the approach taken by the trial judge, and I do so, we say that the judge adopted a rather conservative and reasonable and fair and proportionate approach in the assessment of damages. He didn't separate the awards for the vindicating of the fundamental right from the award of the damages for breach of the right to liberty. Even the interest was awarded from the date of the judgment, and not the date of the filing of the claim. And the criticism made by the Court of Appeal that the general rule that he didn't taper the award of damages, we say that there was, that's not an absolute rule. And on the facts of this case, we say that it sounds more closer to home, as in the case of JM, which the board dealt with fairly recently, which we've put in our written case, and that is in JM, the minor was suffering from Prader-Willi syndrome, and it was in a vulnerable state. And so too we say here, your humble appellants were in fact in a vulnerable state where they're not in full possession of their mental faculties, and they were both detained for prolonged periods, almost bordering on for an indefinite period of time without any intervention. So in those circumstances, we see that the approach, and in JM, the court actually upheld the trial judge's approach, which was to take a per diem approach and multiplied it by the number of days. But
sorry, could you just give us a bundle reference?
Oh yes, certainly I can, Lord. JM. It begins at 845.
Thank you.
Sorry? 855, I beg your pardon. JM begins at 855, my lords.
Thank you.
And we've dealt with this in our written case at page 584, paragraph 88. And the paragraph, if I can take you to 876.
Sorry, you're going to paragraph?
Page 876. This is Lord Borough's judgment.
Yes, thanks.
Paragraph 53. And it reads that counsel for the respondent submitted that there should be a tapering down over time of the per diem award by analogy to the approach taken to the per diem awards in cases of false imprisonment. But the two situations are not analogous. No doubt in false imprisonment cases, the clang of the prison gates can be expected to produce an initial shock to the system that may abate over time. But there is no direct parallel on the facts of this case, and the trial judge was entitled to decide that the same per diem rate was appropriate throughout the time spent in each institution. So we rely on that.
This is subject to your argument about inhuman and degrading treatment. Our case is a deprivation of liberty case, whereas JM was a case about the appalling treatment that the person suffered, being, as I recall, a child who was mentally ill, incarcerated in an adult prison.
No, it wasn't an adult prison. That's CPSAD.
Oh, sorry, I've got muddled them with another.
But there are some the reason we rely on it is there are similarities because they were both being detained at places that were not authorized by law, in a manner not authorized by law, because they were both being kept at the wrong type of facility.
The other point is that the period of time in this case, well, at least at the top of the page, is looking at 371 days. I mean, it's one thing not to taper over a year or something, but here we're looking at 20 years or lengths of that time. To award the same daily rate for 20 years deprivation of liberty as for 2 days is arguably wrong in principle, isn't it?
Yeah, my Lord, I accept that because it should really go upwards as you get closer, as you get past the decades. It ought not to be certainly in law that we say that it gets easier on you the greater the length of time. These are entirely exceptional cases where we're dealing with two persons of unsound mind being kept not in a mental hospital but in a prison, and complete violation of the rule of law. And if anything, I humbly submit that if anything, a standard rate of $500 per day would have been inadequate, and the judge therefore adopted a rather reticent and conservative approach to the award of damages in this case, and it ought not to be disturbed. There's no basis for intervention at this level. We ought properly to uphold that award, and if there is any concern that should justify intervention, we say that the correct thing to do would be to remit the matter so that there can be a proper trial on the assessment of damages in the court below.
But if we were to do that, we'd have to give some guidance as to the proper basis on which it should be approached.
Well, I accept that, my Lord, yes. Yes, if we get to that stage. But our primary position is that the award of damages is not outwit the bandwidth of reasonable and proportionate and fair award that would have been available to the judge on the facts of this case. And bear in mind, the judge in this case, he didn't award, there was no award of vindicatory damages. And if I can just take you briefly to show you what the judge did in this matter, at page 336. At 336, he grants the declaration, but if I can take it down to 5, he awards the sum of damages. If you notice, the interest runs, unlike the other matter, the interest runs from the date of judgment until the date of payment. Normally, interest runs from the date of the claim, and I'll ask the board, if possible, to correct that, quite frankly. But the short point is that there really isn't. I mean, we don't see any, see any basis for. No, the damages. What I wanted to point out. Sorry, my lords. The damages, if you look at it at 5 and 6. In fairness to my Lord Legard, the damages is really linked specifically in 5 and 6 in breach of his right to personal liberty, so that on the cruel and inhuman and degrading punishment, it's an important rider that we support, but on the issue, it would not in any event affect the award of damages because the judge directed his mind to breach of the right to personal liberty in
that's quantum. Isn't that part of the criticism made by the Court of Appeal, that if it's a personal liberty case, one should ordinarily expect a degree of tapering, whereas the judge just applied a per diem rate?
Well, that's one of the criticisms, but we say on the exceptional facts of this case, I mean, that can't be an absolute rule, as the board itself found in JM. And because it can't be an absolute rule, we say that this is an exceptional case that falls more in the realm of the case of JM and the approach taken by the court, by the board in that matter, when it restored the awards of damages made by the High Court and rejected the tapering argument.
It's probably my fault, but I didn't have clearly in my mind what you say are the relevant facts of JM.
JM was a minor who was suffering from Prader-Willi syndrome, and he was placed in. He was being detained in a facility that was not, not authorized by law for his detention, given his age and given his condition. He was in a vulnerable mental state, and he was being taken advantage of. In this case, whilst we don't have any, there is no detailed evidence, what evidence we do have suggests that the appellants were being beaten and taunted, and they were suffering.
But I thought that the judge found that there wasn't any good evidence of the conditions in detention in our case.
No, I accept that, but what I'm saying, there is evidence. It's not that there is no evidence. There is evidence that they said they were being beaten by prisoners and prison officers. They did give evidence in support of their claim, my lord.
Right.
But you're seeking to justify the award on the basis of infringement of liberty, not the treatment.
Correct. And I think what the point I'm making is that the judge himself, in directing his mind to the quantum of damages, that's what he linked it to. So in other words, if the judge, for example, had said, well, look, he wanted to make an additional award having regard to the breach of another right, that would have been a different matter. But the judge did not, which is why I made the submission that the declaration with respect to inhuman treatment is really a part of the vindication of the to underscore the importance of the right and reflect the sense of public outrage at a complete and colossal violation of the rule of law.
The Stevens case you showed us, that was a long period of unlawful detention, is that right?
Yes, yes, my lord, and there was no tapering. And there was no appeal either. The state accepted that as a good approach in that matter.
And what about the other cases that the judge cited, that he referred to in his judgment?
Yeah, my lord, the other cases are false imprisonment cases, my lord. So that,
and were they long periods of false imprisonment?
The periods vary, my lord. We've dealt with for example, the Stevens case. In the Everett Davis case, it was 8 months and 5 days, and they applied $500 per day. In the Jermaine Brown and versus AG of St. Christopher and Nevis, it was 3 months and 3 years and 3 months, and they applied across the board $500 per day.
Where do we find those figures?
Oh, no, sorry, I beg your pardon.
They set out anywhere in.
This is at page 335. 335. Paragraph 63 of the High Court judgment.
But the figures, so we follow up those cases to find the figures.
But those cases are included in the joint bundle. I can give you the references as to where we can find them.
Later.
Yeah. But I was just answering my Lord Legat's query as to the time periods.
Yes, and you hadn't yet given us the last one, Gavin Brown.
Yes, please, my Lord. So that's Gavin Brown was 1 year and 8 months and 3 days, and across the board was 500 per days. Yeah. And those were the 3 cases referred to in paragraph 63. So there are various times. 8 months and 5 days, 3 years and 3 months, and 1 year and 8 months. But across the board, they applied. There was no tapering. It was a straight case of $500 per day. And we said that crystallized, if not a practice, a good principle which the judge was entitled to follow and ought not to be criticized for so doing. Unless there are any questions, I think.
Thank you very much, Mr. Ramlogan.
I'm deeply obliged to the board. Thank you.
Ms. Deal.
Which is a peer review.
Oh, yes. Yes.
Mr. Lear, who's a pupil in Chambers, is effectively providing subtitles for your lordships. But I beg forgiveness in advance that I will most certainly ask you to repeat yourselves if you ask me questions.
Certainly.
My lords, I'll start by adopting the eloquent wording of Lady Hale when she was talking about Mr. Kambadzi and the appeal which is in the bundle at 983. The appellants may not be very nice people, they may not be good people, but neither of them should have been through what they were put through. We have acknowledged by the concessions that were made below and by the absence of a cross appeal that there came a time when their continued detention to see if they would regain their fitness to plead to the very serious charges facing both of them was arbitrary and unjustified, because it was no longer possible for there to be a fair trial, and therefore there was no longer any reason to wait and see if they could regain their fitness to plead.
And when was that time in your submission?
I'm sorry?
When did that time come in your submission?
Where does it? After 12
did
years.
it come a time that their detention became unlawful? Because the Court of Appeal don't seem to answer that question.
They say 12 years.
Oh, do they?
They work on the basis that after 12 years it is not possible to have a fair trial. That's at page either 482 or 462. I can't see my handwriting. I think it's 482. Yes, 482, my lord. After that 12-year point had passed, obviously both of the appellants were detained for a considerable period of time. They did have treatment, they did have care, they were largely, both of them, kept in the medical unit at Bordelais, but of course they couldn't leave the prison. Their constitutional right to the protection of law was breached.
But how is it justifiable to imprison them for an offence for which they have not been convicted until, in one case, after the maximum time that they could have been punished if they had been convicted?
Well, they were detained on the basis that they were unfit to plead to the charges. They were entitled, we say, to be detained until such time as they regained their fitness. And they
detained, yes, but not imprisoned. Not imprisoned. That's the problem here, isn't it?
Well,
they were sent to a prison.
That's certainly the appellant's case.
No, what's your answer to why that was justifiable in principle, to imprison somebody for a crime they'd not been shown to have committed?
Because it was within the scope of the discretion that was open to the trial judge for both of them, who had heard such evidence as there was relating to their fitness and such conditions as, or such mental health conditions as they were under. There was no mandatory requirement under the Criminal Code, or to the extent that it applies the Mental Hospitals Act, that they be detained in a mental hospital and nowhere else. If it was not mandatory that they be detained in a mental hospital, then it was discretionary. And it was no part of the appellant's case below, as the Court of Appeal identified, that the discretion on the part of anybody below ought to have been exercised in favour of a mental hospital. So the appellant's case was, and as I believe still is, that there was a mandatory requirement, either because that is how you construe the criminal code, or because you have to read into it the provision in the Mental Hospitals Act, or by reference to Strasbourg jurisprudence that provides that only a mental hospital would ever have been appropriate for both of these men, and of course not just for both of these men, more widely for anybody who is assessed as being unfit to plead.
There's no evidence in this case that the discretion. There's no evidence in this case that the discretion was exercised at all by the Governor General.
There has to be, we would say, a conclusion that the judge who oversaw the jury who decided that they were unfit to plead exercised his discretion, because the order was made as to where both of them should be sent.
If it was any discretion exercised, it could only have been on the assumption it would be for a very short period of time.
That we would say no. It doesn't follow that the discretion and therefore the authority to detain was only ever going to be time limited, because the provision was, I get the precise wording, but I think it was until the Governor General's pleasure shall be known. That didn't bring, effectively, what the judge says goes.
Well, the judge was in breach of the obligation to report the matter to the Governor General, was he or she not?
I think the furthest that we could accept, my lord, is that there is no evidence that it was done. There's no concession on the part of the state that it was not done. Mr. Justice Smith said that he'd formed the impression, perhaps, that in common with many other Caribbean jurisdictions, that it wasn't generally referred to the Governor General. We make no comment on that at all.
Well, either the judge was in breach or the Governor General was in breach.
I would accept there's no evidence that it was expressly referred to the Governor General, and I would accept that there's no evidence that an order other than ongoing detention in prison was ever made by the Governor General.
But still, I'm having difficulty believing my ears. In a civilized country, you cannot keep people in prison for 12 years in the hope that one of these days they might be able to be put on trial. You're talking about detention which is not warranted because they've been found to have committed any crime, or detention warranted because they've been made subject to some order compelling their detention in a hospital, for example, because they're dangerous and mentally ill. It's purely, I mean, on the way you're presenting it, it's possible for some. I mean, Dr. Manette in A Tale of Two Cities is detained for 14 years. The Count of Monte Cristo is detained for, also, as it happens, for 14 years. These are regarded in literature as the exemplars of arbitrary detention. And you're saying that it's perfectly lawful to keep somebody for 12 years in prison, unconvicted of anything, simply in the hope that one of these days they might be fit to be tried.
What I'm saying, my lord, is detention in prison for people who had been found unfit to plead was not mandatory. It was discretionary. It was no part of the appellant's case below, as the Court of Appeal noted, that the discretion ought to have been exercised in favour of a mental hospital. The case was always on the basis that the only order that could have been made was that they should be detained in a mental hospital. So the first question, my lord, that we say falls to be considered is whether detention in a mental hospital was mandated. Now, 3 points, effectively evidential points, that I would raise as background, which are of relevance before I deal with the principles, which will probably take us almost until lunch. The first is this. Dr. Gilliard, who was the consultant psychiatrist both at the hospital and at the prison, at least from the time that Bordelais opened in 2000, we started there later on, confirmed that the hospital was not equipped to accommodate inmates. That's at page 261, and then he says the same thing at 111, because of course he put in separate affidavits for both men. Whether or not that should be the case is neither here nor there, but the hospital, the mental health hospital, was not equipped, he says, to accommodate inmates. The second point...
By inmates, you mean... what do you mean by inmates?
I can only say that that is what he says.
Everybody in a hospital is an inmate, and one might say.
Well, he doesn't say those who are under penal sentence, those who are... the wording he uses is inmates, and I can do no more than repeat that that's what he says. The second...
Well, if you're relying on it, then we need to know what significance, if any, is to be attached to that. And on its face, it doesn't mean anything. I mean, anybody, it must have been equipped to accommodate people, including those who haven't been convicted of any criminal offence.
The second point, my lord, that I would make in that connection is, at least in respect of Mr. Knoll, there is evidence that treating doctors had refused to treat him anywhere other than a prison. There are 3 references to that. The references are at 251, 269 and 315.
If I have those again, please. I'm sorry. Those pages again, please.
251.
Yes.
269 and 315.
And what do you say I don't want to sound rude by asking, so what? But what do you say the legal implications are of that?
Well, at this stage, my lord, all that I'm seeking to do is go through 3 points that I say form part of the evidential background, which are not in the statement of facts and issues for obvious reasons. The principles and the extent to which they're going to be relevant, that I will, if I may, elaborate on shortly. But effectively, what the upshot, at least in respect of Mr. Knoll, of what is being said on his behalf, is that the only place where he could possibly have been detained and where he was expected to have treatment and where he was expected to have care to see whether he could regain his fitness to plead was in fact a place where on at least 3 occasions the doctors have said, we can't treat him here. So if one's looking on the principles of the only possibility is a mental hospital, and of course these are principles that have to apply absolutely across the board of everybody who's found of unsound mind, then the difficulty, we say, of that conclusion is really put into sharp focus by the specifics of Mr. Knoll's scenario. That if one has to conclude that only a mental hospital would do, or could ever have properly been ordered, it is relevant in my submission to bear in mind that actually for this gentleman, at least, that was a place where the psychiatrist said, not safe. And the third point that I would simply raise as part of the evidential background is this, that Mr. Gard, who's the Director of Corrections at the prison...
I'm sorry to interrupt, is this going to become, is it a sort of causation argument? That if the law had been followed, they'd have been in prison anyway? Is that the argument?
No, it's that it cannot actually be a proper construction of where people found of unsound mind should be detained, that only a mental hospital could ever be appropriate. There has to be, we say, an element of discretion, and that is the element of discretion that is expressly given to the judge and to a lesser extent to the Governor-General. That's what the appellants say didn't exist. They didn't argue that there was a discretion and the discretion was exercised wrongly. They've said there wasn't a discretion. We say, yes, there was a discretion, and the specifics of the way that Mr. Knoll's condition presented itself shows why that discretion is actually really rather important.
So you're saying, I mean, I'm reading between the lines here, but I take it that you're saying this on the basis that the relevant provision is Section 1021 of the Criminal Code, yes, rather than Section 31 of the Mental Hospitals Act.
Well, I will look at both of them, my lord. But the original order that both of the separate judges made in respect of the separate appellants was certainly pursuant to the code, because at that point they were under the criminal justice system, and that was regulated by the criminal code. And
presumably you're going to deal with the issue that 1021 envisages the court making an interim order pending a final order by the Governor-General.
Well, we would say that it isn't intended, it shouldn't properly be read merely as an interim order. It's an order until something else happens, but if something else doesn't happen, it doesn't invalidate the original order. That's the nature of it. It's not a... If the second step doesn't happen, the first step was invalid.
But you don't... In pre-revolutionary France, the situation that gives rise to A Tale of Two Cities is they had what was called a lettre de cachet, And once such a letter was issued by a person in authority, you threw away the key. The person was just detained indefinitely. Now, I'm reluctant to construe the Criminal Code of St. Lucia as authorizing orders which have the same effect, but it rather sounds like it. I mean, if this is all we're relying on, that the interim order made by the court can last indefinitely, there is no, well, you need to take it, if it's not to be in effect the same as the French letter, then we need to understand what then follows in terms of the person's discharge.
It wasn't indefinite for precisely the reasons we say that the Court of Appeal accepted, because of course the appellants are entitled to protection of law, and they could be detained only for as long as the purpose for which they were ordered to be detained could serve a purpose.
12 years?
Yes.
Well, frankly, that's absurd. It would be a disgrace if we were to hold that that was the law of anywhere, I think.
I mean, saying in one case that it was satisfactory to imprison somebody who had not been convicted of an offence for longer than the maximum term for which it would have been satisfactory to imprison him if he had been convicted.
Well, that wouldn't in and of itself be inappropriate, because one can be on remand for quite some period. In fact, that's the position they're in. They've been charged. But
no, they're not on remand anymore, because now there's a verdict that they're unfit to plead. So they're not simply being remanded pending a trial.
They still have the charges hanging over them. They're not innocent men. They are presumed innocent until proven otherwise, but they have not been exonerated by a finding of the jury that none of this happened or that they weren't responsible for it. So they still have the charges hanging over them. And at the point that they regain their fitness to plead, then the charges are still there.
But why your submission is unacceptable is you're saying it's acceptable to imprison somebody who's presumed innocent for longer than it would be acceptable to imprison somebody who'd been found guilty
I'd say
at that point of their trial.
It's acceptable to detain someone whilst they are unfit to plead.
No, but to detain them in a prison on exactly the same basis as if they'd been convicted. That's your case.
No, it's not, my lord. Our case is that it was lawful to detain them because, and in fact, mandatory to detain them because they'd been found unfit to plead. The where of their detention was something that was discretionary. It was up to the judge to say, as he did say, I'm assuming in both cases, that it should be in prison. It was not mandatory that their detention after the finding that they were unfit to plead should be only in a mental hospital. So,
well, you assert that, but judges don't normally have a discretionary power to send people not convicted of a crime to prison indefinitely.
Only for so long as the purpose could still be served. That was what the Court of Appeal said. It was never going to be indefinite because it was always going to come to an end once it became arbitrary, or it should have come to an end once it became arbitrary, which is why there's been no cross appeal against the Court of Appeal's finding in that regard.
Sorry, could I just ask you this? On section 1021, page 629, surely the purpose of the court's initial detention, which I can see you say from the language is discretionary, is to hold the position over until a more important decision is taken by the Governor-General. And one sees that from the structure of section 1021, and in particular in section 1021(2), where it says the judge shall immediately report the finding of the jury onto the Governor-General, and in effect the parcel is handed over to the Governor-General. So I'm not quite sure why you're focusing on the purpose of the court's order as though the court was holding the position over until trial. Surely the court's holding the position over until the Governor-General. And then once one gets into section 1021(2), The Governor-General's decision-making is highly structured, it might be said, because he's subject to an obligation to treat in a particular way unless he positively exercises a discretion in another way, which he never has.
As my Lord identified when that point was being taken through by my learned friend, that it had to be, as far as the Governor-General was concerned, it had to be in accordance with the laws, or otherwise as he thinks fit. So it's still an entirely general discretion. But the reason why I'm concentrating...
So just to break down my question, because it was a slightly long one, there are two questions really to you. The first is, looking at the court's discretion, isn't the object of that simply holding over until the Governor-General makes a decision, rather than generally holding someone until they can face trial? And then the second question is, if you could help us, or help me at any rate, in relation to what the Governor-General is supposed to do if it ever reaches him.
My Lord, since those are going to be relatively lengthy, I wonder if, since we're 4 minutes before 1, if I'll start with both of those as soon as we come back again. I'm conscious of the time limits that I have, but the reason why I'm concentrating, at least at this stage, on the order that the judge made is, of course, because the appellant's case is that the detention was void ab initio. So there's no part of their case that now, at any rate, that it was. I mean, I say that because the Court of Appeal identified that it was initially accepted that the order that was made was valid. Now, what is being said by the appellants is that the detention was always unlawful. It could never have been lawful in a prison. So that's why I'm concentrating in the first case on the order that the judge made.
But then the difference may be between always unlawful and whatever period of time is immediately, 2 days, something like that.
Well, immediately in terms of the reference to the Governor-General doesn't necessarily mean that the decision gets made immediately, and given that there hasn't been any evidence or any consideration of what period of time it might be reasonable to allow a Governor-General to be making that form of decision, we're not talking about the same things as deportation decisions.
But I mean, one would still think within 2 weeks, something like that. I mean, are you really going to argue the case on the basis that if you can show that there's one day when it might have been possible for someone, either the court or the Governor-General, to exercise a discretion for the person to be in prison before shifting them over to a mental institution, the claim falls away?
No.
No, all right. But in that case, I think you then do need to address.
So if I address those 2 points, my Lord, then at 2 o'clock.
Yes, thank you. We'll resume at 2 o'clock.